somewhat building on from last week, we're now going to look more at the adjudication and the disposition of juvenile courts. So, kind of the sentencing structure more than just the structure of it, I guess you could say. So, adjudication is the judicial decision that the facts alleged against the juvenile, either by the petition or by other means, whether it's true or not true. They'll have a hearing, just like adult courts. If the judge decides that the facts are true and that the juvenile committed the delinquent acts, then they will have some sort of disposition imposed, whether it be a detention or some type of probation. Dispositions are the juvenile equivalent to sentences. There can be nominal, conditional, and custodial. Nominal dispositions are the least punitive of the three. They are usually a verbal warning or a reprimand of some kind, and they release to the custody of their parents or guardians to complete the action. Conditional dispositions are essentially similar, but they're going to have some probationary options. Youths are placed on probation and required to comply with certain conditions. And then custodial dispositions are either non-secure custodian or secure custodian, secure custody or in non-secure custody or confinement. Non-secure custody is placing the juvenile in somewhere like a foster home, group home, camp, or school. Secure confinement, it would be the equivalent to incarceration. And then non-secure confinement could be a treatment facility to ensure public protection. Foster homes, group homes, and camps and ranches are all similar non-secure custody confinements. Minimizing the confidentiality of junior court records and proceedings, we're shortening the time between the arrest and the disposition. Attorneys as a matter of right, guardians ad litem, and then jury trials and plea bargains are also possible now. A transfer of venues or a waiver would essentially mean that they're waiving their right to a disposition and transforming more into kind of the criminal court system than the juvenile court system, but it gives them the opportunity to go forward with whatever reprimand they'd be receiving. Rationale for transfers would be to make it possible for harsher punishments, to provide just deserts and proportionately severe punishments on juveniles who commit violent actions, to foster fairness and provide a deterrent, to overcome the leniency of juvenile courts and become more realistic, and to make the youths realize the seriousness of their offenses. So we want to make sure that we're balancing providing adequate care for that juvenile with making sure that they receive punishment for what their actions are. In 2004, 13,000 youths were transferred to criminal court. Most juveniles were transferred were male, and about 7,200 or 54% of all transferred juveniles were Black or other minority. Those who charged offenses and waived to criminal court made up 41% of those transferred. About 44% of those charged with property or public order offenses were waived. About 14% of those waived were charged with drug offenses. And then table 12.1 kind of shows that difference. There are four types of waivers. There's prosecutorial, judicial, legislative, or demand. Prosecutorial is the prosecutor has the sole authority to make the determination whether a juvenile case should be heard in criminal court or juvenile court. Obviously, it has to be a pretty severe offense. Judicial shifts the burden over to the judges determining that factor. Legislative would have to do with statutorily prescribed list of crimes that would be transferred over to the criminal courts. And then demand would be the request by the juvenile and their attorney to have the court transferred from juvenile to criminal. Once an adult, always an adult. So once they've waived their age, they will be forever considered an adult for the purposes of that particular criminal prosecution. Again, all juveniles who are waived to criminal court for proceedings are entitled to a waiver hearing. A waiver hearing is a formal proceeding designed to determine whether or not the waiver was taken correctly. And for those jurisdictions with legislative waivers, waiver action may be contested through that hearing. Juvenile court proceedings are civil, remember, not criminal. Thus, juveniles do not acquire criminal records. Juveniles are less likely to receive sentences in incarceration, and there is considerably more sympathy, obviously, for youth offenders. Compared to criminal courts, juvenile courts do not have an elaborate, let them elaborate on their information. They are there to be adjudicated and then determine the way that they are handled by the courts. I don't necessarily want to say punishment, but whatever their actions occurred. Life imprisonment and the death penalty lie beyond the jurisdiction of juvenile courts. That can only be imposed by criminal courts. Compared with criminal courts, we already went through that one. And then there can be some blending sentencing referrals, and it will take the juvenile court system as well as the criminal court, and they kind of blend them together. Increasing the number of jurisdictions are using teen courts as an alternative to juvenile courts to help get offenders through the proceedings and lets jurors consisting of teenagers hear and decide the cases. So it actually is a court of their peers. In 1997, there are 78 active teen courts. By 2005, there were over 1,000. Beginning in 2000, they handled about 1.5 million cases, and it helps allow other teens to understand the ramifications of actions, and it gives them the ability to be heard by their peers. Are they successful? Well, it goes back and forth. One positive that is reported is that many youth emerge with a greater appreciation for the law. Case of Voss and Van in 2013 revealed that the completion rates for the participants in the 12 studies went from 62% to 100% completing their teen court sentences, which definitely sounds promising and beneficial. And so we're going to see if, in fact, those continue to be the future of juvenile courts, and whether we're going to move more to adversarial and less proactive and rehabilitative. It could also form that criminal courts become, juvenile courts become a lot more like criminal courts and a lot less like civil courts. And so we'll have to see kind of how we all feel about that.